Good morning. We welcome you all to the MTB Lecture Series 2025. There is no better way to start the lecture series of 2025 with the first speaker being none other than our Honorable Chief Justice, Shri K.R. Shriram. We shall begin this program with Tamil Thai Valthu. I request Jayalakshmi to kindly do the honors.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலுழுகும் சீராறும் வதனமென திகழ்வரத கண்டமிதில் தெக்கணமும் மதிசிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறன் வியல்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Thank you, Jayalakshmi, for that wonderful rendition. Good morning. Our President, Mr. Pramod Kumar Chopra, and our Secretary, Mrs. L. Maithili, to accompany the Honorable Chief Justice to the dais. Please. Thank you. I now request our President, Senior Advocate, Mr. Pramod Kumar Chopra, sir, to deliver the welcome address, please.
My Lord, Honorable Justice Shri K.R. Shriram, Chief Justice, Madras High Court. Okay. Honorable Judicial Member, Head of Department, CAT, Chennai Bench, Mr. Swaminathan. Honorable Judicial Member, IT Bangalore Bench, C. K. Soundarajan. Learned Government Pleader Pondicherry, S. Ravi Kumar. Learned Senior and Junior Standing Counsels for CBDT and CBIC. Learned SGP, AGP and Government Advocate Taxes. Vice Presidents, Secretary, Treasurer, Librarian, Conveners, EC members of MTB, members of the legal fraternity, and my fellow MTBians. Good morning. I welcome and thank you all for joining us on this significant occasion, the MTB Lecture Series 2025. At MTB, we take immense pride in fostering a vibrant community dedicated to the exchange of ideas and the advancement of knowledge. Over the years, MTB has become synonymous with initiatives like our webinar series launched during the lockdown and continued to this day, and our monthly e-newsletter, which not only showcase insightful articles from seniors but equally from juniors, and also include engaging games centered around tax subject. Above all, the camaraderie among our members, whether representing assessee or the revenue, stands as a testament to the collaborative spirit that defines MTB, as we strive together to lay down principle of tax laws. This camaraderie is not something new, and it was inhabited in us by giants of tax bar like C.V. Ramchandran, Ramamani, Natarajan, Habibullah Basha, former AG R. Krishnamurthy, Chandran, Trilokchan Chopra, C. Venkatraman, and living legends like Somyaji, Ramani, Arvind Dattar, Pushya Sitaraman, N. Venkatraman, presently who is AAC in Supreme Court, to name a few. Kindly pardon me for having missed out some more names. Their immense dedication, hard work, and value in the profession, with sole aim to deliver justice and lay down principle of law, have created an eternal light which will always keep guiding us and showing us the right path. Today, as we celebrate the completion of 75 years of the Constitution of India being in force. In fact, today is the 75th, last day of 75th year. The Constitution has come into force from 26 January 1950, and today happens to be 25th January 2025, which is completion of 75th year. We are reminded of its enduring legacy as a living document that continues to guide and shape our nation. With 106 amendments, it has demonstrated an extraordinary ability to adapt to the evolving needs of society while preserving its foundational principle. Drafted with a vision of equality, liberty, justice, and fraternity, our Constitution remains the bedrock of our democracy. As we step into the final quarter of a century, leading up to our Constitution centenary, it is an opportune moment to reflect on how the Constitution has shaped not just only governance, but every aspect of our social, legal, and economic system, including taxation. It stands as a symbol of inclusivity and resilience, ensuring the delicate balance between the powers of the state and the rights of its citizen. The Constitution also underscores the pivotal role of tax law in economic development of the country, ensuring equality, transparency, and accountability in governance. This remarkable journey of 75 years reaffirms that our Constitution is not just a document of historical significance, but a living force that continues to evolve, safeguarding the aspiration of over 1.4 billion people. It has witnessed transformative changes from landmark judicial interpretation to reforms in fiscal and tax policy, all while ensuring that the pillars of democracy remain steadfast. Against this backdrop, it is truly an honor to have with us our Honorable Chief Justice K.R. Shriram as the first speaker of our lecture series 2025. My Lord was born in Mumbai on 28 September 1963, holds an illustrious academic record with BCom in Financial Management and Financial Accountancy and Management, LLB from Mumbai University, and LLM in Maritime Law from the prestigious King's College, London, where he graduated with merit. He began his legal journey in 1986 and over the years built an exceptional career specializing in shipping law, international trade law, arbitration, and taxation. He was elevated as additional judge of the Bombay High Court on 21st June 2013 and was confirmed as a permanent judge on 2nd March 2016. My Lord was elevated as Chief Justice of our Chartered High Court on 21st September 2024 and assumed the office on 27th September 2024. His judicial contributions span landmark judgment in tax laws, admiralty law, company and IBC law, civil law, etc. that serves as a guiding precedent. Some of his landmark decisions are Raj Shipping Agency versus Barge Madhwa, an admiralty law, decision on admiralty law, which I am sure my Lord will be referring in his today's lecture. Asset Auto India Private Limited versus Union of India under companies and IBCL law. Romano Pinto versus Deputy Commissioner of Income Tax under Income Tax law. Hemant Surgical Industries Limited versus Union of India under Customs law, etc. Beyond his courtroom accomplishment, our chief has actively contributed to social cause as the Vice Chairman of Dharmist Mitran, an NGO supporting bereaved families. It will also excite you to know that my Lord is an avid golfer and traveler. He indeed brings a remarkable blend of dedication, expertise, and compassion to his work and life. My Lord continues to leave an indelible mark on the legal landscape. We are privileged to have my Lord Chief Justice with us today to share his insight on shipping law and practice, a subject of immense significance in the evolving legal and commercial world. His profound knowledge and practical experience will undoubtedly enrich our understanding of the said law, and more particularly when our state is emerging as a hub for maritime activities supported by flourishing major ports. We eagerly await hearing from your Lordship. On behalf of everyone at MTB, I once again welcome the Honorable Chief Justice and other dignitaries present. Thank you. Have a wonderful day.
Thank you, President, for your wonderful speech. and introducing our Chief Justice to us and giving insights on the Constitution of not just being a historical document but a living legend. And of course, giving a highlight of what we do in MTB. Thank you very much, Mr. President. Now I request the President to kindly felicitate Honorable Chief Justice Shri K.R. Shriram. I also request the conveners of MTB, Shri A.P. Srinivas and Dr. Krishnanand, to come forward and felicitate Honorable Chief Justice. Atta. Thank you very much. Now I request our past President, Shri Mani Shankar Sir, Senior Advocate, to kindly felicitate Honorable HOD CAT Chennai Bench, Shri Swaminathan Sir.
I now request our past Vice President, Mr. Satish Sundar Sir, to felicitate Honorable Member Judicial Mr. K. Soundararajan, Member of the ITAT.
I'm really sorry. There was another felicitation for the Chief left. I request Senior Advocate Shri R. Venkatraman Sir to kindly hand over a bouquet to our Chief Justice. I'm sorry, I forgot. Before we proceed to the most awaited session of the morning today, I would like to inform all of you that our Honorable Chief Justice was gracious enough to accept our request to have a question-answer round at the end of the session, which has been the key highlight of all our webinar and lecture series. So I thank you, my lords. I request the audience, if there's any question, to kindly give your names to our volunteers who will be around the hall, so that it will be smooth in asking the questions. We'll call out the names of those people if the time permits, and those questions can be asked to the Honorable Chief Justice. So I thank you once again, and I request the Chief to kindly deliver his lecture today. Thank you, sir.
Shri Sampath Kumar, Ms. Maithili, the dignitaries present here, leaders of the bar and the future leaders of the bar. Today it seems to be a forgetful day for Mr. Chopra. He forgot about Sri Venkatraman giving me a bouquet, but the biggest forget is my office forgot to put the entire bundle of papers for me, what I was to use today to speak. So they all wanted to test my memory. And I must thank the Madras Tax Bar to have invited me for this function, because the love affair with the tax bar has been going on pretty smoothly, which started way back in August 2021. Just to give a background about the tax bar and then to the topic. End of July, I think it was 30th or 31st of July 2021, my then Chief Justice, Justice Datta, called me up in the evening and he said, "Brother, you're going to be heading a bench from Monday and you're going to head the tax bench." And he said, "I know you have never headed a bench before, it's the first time. You have never had any experience in the tax bar, on the tax side. But I'm giving you Justice Ahuja as a partner. So I think he'll be there to help you in case you need. But I assure you, after a month or two, I'll move you to your comfort zone. That's the commercial law side. I should tell you, after a month, my partner changed. I was left to fend for myself. I went and, the second month, went to the Chief Justice and said, "Sir, you assured me that you will move me to my comfort zone. This is my comfort zone. Please do not move." And that was only because of the wonderful tax bar that Bombay had. And I learned a lot. I learned a lot from them. And that's not the end of the story. In the next 9 months, I had 6 more partners. Not because nobody wanted to sit with me. The chief felt that you sit with him, you all will learn, because very soon he is on his way out, so I can have somebody who can take over the mantle of the tax bar. I felt very happy with that. That's the confidence that the Chief Justice had in me. And then I got a hiatus. I did indirect tax for 6 months, and then indirect and commercial appeals for 6 months, and back to direct tax again. After 6 months, the then Chief Justice, who is now the Chief Justice of Delhi, Justice Upadhyaya, said, "Brother, do you mind if I continue you for 6 more months in the direct tax?" I said, "I'll be too happy to continue." The reason is that people see a ghost in the tax assignment where there is none. It's one of the most wonderful assignment anybody can do. And the best part of being in the tax bench is you don't need to worry much about facts. You don't need to be on the guard as to whether the counsel is trying to be a little fast on you. Not that in some matters we have to be on the guard. And I was telling them yesterday, every individual wants a feedback on their performance, because that helps them. It's natural. And many come and praise you, many say a lot. It need not be always true, and many may not speak the truth also to even tell you whether you're doing bad. But in the tax bench, the best feedback I got was, that's the style I worked, is I would take the section, analyze it, break it up, and then ask the lawyer, tell the counsel, this is the way I read and the way this section should be read. And the counsel will say, that's exactly what the Supreme Court has said. And that was a feedback which goaded me to go ahead in the tax bench. He forgot to mention about my hexaware judgment, that was the last one, which is a masterpiece. Anyway, now going back to the topic that we decided to speak, because first of all, the time is too short for me to prepare. And secondly, there are too many things to be done, so I requested them if I could speak on my comfort zone, where I don't need to spend much time to prepare to speak, because the audience we have, you're all going to be judging me as to how I am. The Admiralty Act, we never had one until 2017 when the Admiralty Courts Act was introduced. It was judge-made law. And the peculiarity about the Admiralty jurisdiction is you can sue a ship. The reason being, in olden days, ships would go, even now, ships go from place to place. The owner of the ship is not known, and most of them were tramp vessels. So how do you sue the owner whose identity you do not know? So you sue the ship, treating it as a person. So when you sue the ship as a person, You can also move for arrest. It's easier than an attachment before judgment that you find you do under the Code of Civil Procedure. And there are procedures mentioned under the Admiralty rules. And once you arrest the ship, the owner or the person interested in the vessel has to put up bail. And if the bail is not put up, then the Admiralty Court will auction the vessel and the sale proceeds are available for the benefit of all creditors. That is how the Admiralty jurisdiction functioned. And then you need to arrest the ship. Of course, there is also an extension. Because the claim is against the owner of the vessel, you can arrest a sister ship, provided she is the sister ship when the claim arose and when you are filing the suit. There are two kinds of claims under the Admiralty jurisdiction that you have. There are 20 heads mentioned under the Act. And there are two parts. 6 of them are called maritime liens, and the remaining are called maritime claims. All maritime liens are maritime claims, but all maritime claims are not maritime liens. The difference is, for a maritime claim, the owner should be the owner of the vessel when you're moving the court for arrest. Claim arises on a particular date. When you move for arrest, he should be the owner. If the ownership has changed, you cannot go against the vessel. But in a maritime claim, maritime lien, it goes with the vessel. Even if the vessel is sold, you can still go and arrest the vessel. Under the new Act, we have a cutoff of 1 year. But earlier it was not so. You could go ahead and the excuse of, I'm an innocent buyer doesn't arise. And when the sale happens under the Admiralty jurisdiction, the sale is free from all encumbrances. So whoever has a claim prior to the date of the sale has to go and put their hand in the kitty. And that, who gets how much, the priorities are decided under the provisions of the law. That's where Barj Madhva that he mentioned was one of those landmark judgments which I felt very happy. Used the COVID time, wrote it by hand, then typed it myself. And but for COVID, if I had the benefit of my secretary, I would have written another 40 pages. Sorry. There, the interesting point was, it was an interplay between, it's Raj Shipping Agencies versus Barj Madhva. It was in May 2020. It was an interplay between the Admiralty jurisdiction, IBC, and the Companies Act. If the owner is in CIRP, Corporate Insolvency Resolution process, what happens? The argument was, there were two sides of argument. One certainly was saying, sorry, you will have to hold your hands. Admiralty Court cannot because moratorium takes precedence. I went on to hold that in the Admiralty jurisdiction, the suit is not against the owner. Mind you, in Admiralty, a suit when you file, you can make only MVX defendant. You don't need to make the owner anyone else as a party defendant. So I said, the suit is against the vessel, not an asset of the company. And therefore, moratorium will not come into play. And if the vessel is sold, if the owner does not, if the RP does not come forward to furnish security, the Admiralty Court will go ahead with the sale of the vessel. But because then the money belongs, because the surplus of the sale proceeds, if any, will go to the benefit of it will go to the company. The money belongs to them. Because of that, if there is a moratorium, until that is over, the priorities will not be decided. See, the issue was there was a lot of opposition from the financial institutions initially, because under the IBC, they take away the entire money. Very, very, just crumbs are left for the operational creditors. Whereas under the Admiralty jurisdiction, the priority goes first to the crew. Whoever have maritime lien, they get a priority. And then only the statutory lienees, that's the maritime claim holders. So the banks would come somewhere number 5, the financial institutions. And I also went on to hold that it is in the interest of all creditors that the Admiralty Court goes ahead, arrests, and proceeds to sell the vessel, because the sale is free from all encumbrances, which is not so under the Insolvency and Bankruptcy Code, because if the resolution professional sells a vessel, of course he gets 7% of the sale proceeds. That sale need not be free from encumbrances. So you wouldn't get so many buyers, because nobody knows what are the hidden encumbrances, though there will be an indemnity clause providing that if there is any other, etc., etc. It's again, you're exposed to litigations. And because Admiralty sale is free from encumbrances, you get more bidders and better bids. In fact, I have conducted auctions in the court, open court, and I have seen bids going up by at least 400%, from 2 crores with the bid going up to 21 crores to sell the vessel. Because everybody forms a cartel when you try to sell some product. So that was a study which, in that judgment, Barge Madhava, we went, and many of the financial institutions later were happy with this because they could get a better bid from the sale under the Admiralty Code. So that is how the Admiralty jurisdiction functions. So earlier we could arrest a ship anywhere in the country, Bombay, Madras and Calcutta, which were the chartered high courts. We could arrest, so Bombay, we would move for an arrest of a ship which is in Paradeep or in Haldia or even Kandla or Madras for that matter. But now with the Act, 8 courts have Admiralty, which are the coastal states have Admiralty jurisdiction. Bombay is really developed very well. Madras, yes, would put next, and Calcutta. But other places, even now, there is still how to, the thinking. By default, people will think how the Code of Civil Procedure will function. Whereas here you need to think a little different. So that's how the Admiralty Court Act began. And then when you have Admiralty disputes, you have various claims that would come. One particularly relating to the ownership of the ship. You would have disputes of necessaries supplied. If bunker is supplied, fuel is supplied, it's not paid for. Then you go against the ship. It's not a maritime lien, it's a maritime claim. But if a crew member's wage is not paid, or for example, the vessel met with bad weather, heavy weather, and she needed salvage services, and salvage service is rendered. The salvors have a precedence over everyone because they are protecting the asset for the benefit of all those interested in the voyage. So they stand higher in priority compared to others. But the salvor's claim will have a maritime lien. So these are the issues which come up. And one of the most common, which everybody would have come to know or would have come across, is cargo disputes. Because ships are used to carry cargo. And how do they carry the cargo? There are 2 kinds of contracts which are entered into, which I'm sure with your experience you would have heard about. Is one under charter party, and the second is under the bills of lading that is issued. Going in the reverse order, bills of lading, which we cover under the Bill of Lading Act 1855, 1856, I think UK is 55. 56, where the bill of lading acts as a receipt, it acts as a ownership document, and it's a transferable document, not a negotiable instrument, but a transferable document. Charter parties have three kinds of charter parties by and large. One is time charter, the other is voyage charter, the third is bareboat or demise charter. There is no rocket science, again, like in the tax laws you find. I'll tell you a simple example as, what is time charter? I mean, even when I started, I used to wonder, I spent a lot of time trying to understand what is time charter. I'll give you a simple illustration. You hire a taxi, go to Hertz Rental, or which is a taxi company now here. Zoom cars? Or Zoom cars, I think there is one where you hire a car. No, Ola is like Ola I'll come to, that's Voyage. You hire a car for a month. Who pays for the fuel? You pay for the fuel. You can be self-driving, or you hire a car with a driver. For a week, you come to Chennai from Delhi, or you go to Delhi, or Bombay, you hire a taxi, keep it, you say you're with me for a week. So you pay per day hire. He says 80 kilometers per day plus actuals. And I'll drive you only within Delhi city limits or the NCR region, not beyond. That is time charter, where you hire a ship for a particular period, where the crew, so your owner gives you the ship with the services of the crew. So the master, crew, all are the employees of the owner. You pay for the bunker, the fuel, and you are given a trading limit within which you need to use the vessel. The second is voyage charter, what Sri Sampath Kumar mentioned, Ola. You hire a taxi from Nungambakam to the airport. The driver is the owner's employee. The vessel belongs to the owner. Fuel is his. He'll down the meter. You pay for the meter. So everything is paid for. He takes you from Bombay or Chennai to Dubai. That's the voyage that is hired for. So as a taxi with certain, depending on the bargaining that happens, basically that's the principle. Third is, it's a demise charter, where your car lease rentals. A person has a lot of money, he buys a ship but doesn't know how to run a shipping business. So he gives it to an expert on demise. It could be like the hypothecation or not hypothecation, hire purchase, sorry. And after the end of 5 years, for a small amount, you become the owner of the ship. That is how the whole thing, though he is demised to him, he is for all purposes deemed owner of the vessel. That's how the charter party system functions, business functions. But in the course of charter party, there could be a situation, two kinds of situations. One is, let's say I have a huge mine and I'm like Sterlite, Vedanta. From my Goa, from the mines, I move my iron ore to Genoa in Italy. I have so much of cargo, I don't need to keep bothering about chartering vessel. I use my vessel to carry only my cargo. But all need not be like that. Many may hire a ship for a month or for a year and then use it for voyages. They will use it for like the shuttle service between Bombay, Dubai. Many of today with the containerization, all don't carry cargo from place A and up to the place of destination. They have those hubs. They drop it off at Dubai. From Dubai, another vessel takes it to Rio, from Rio to some other place, and then finally to Houston, or this side you have Colombo to Singapore, and then so whenever that's another feeder, I'll come to that. But in a normal circumstances, in a voyage, so in a time charter that he has, the charterer issues a bill of lading for someone whose cargo he is carrying. So there are two kinds of contracts which are involved. One is between the owner and the charterer, which is the charter party, and the cargo interest, somebody else, a third party has placed this cargo to be delivered at destination. For that, a bill of lading is issued. That's a second contract. The cargo does not belong to the charterer. The cargo belongs to the third party. When the cargo arrives at destination, arrives damaged. So the receiver or the consignee there, his contract is the bill of lading and not the charter party. How does he sue? He will sue on the bill of lading. I'll park that aside for a moment. But how the industry today functions, which is how, you all would have seen, is cargo is moved in container today. The bulk vessels have reduced to a large extent, even scrap. Earlier it used to be in bulk vessels, now they are all packed into containers and containers are moved. There are two kinds of operators who are NVOCCs, non-vessel owning common carriers, and also ship owners. Many of them have these feeder services. So there are two kinds of bill of lading that is issued again. One is called a house bill of lading and the other is called a master bill of lading. The house bill of lading, let's say Mr. A, he is carrying on business as a NVOCC or a multimodal operator, but no, he doesn't have his own ship. But he's a big player. X has a ship, but he does not have the wherewithals to get the cargo. So let's say it's a 450 TEUs, 20 equivalent unit ship. So he gives on slot charter to various players. So he gives, okay, you take 100 containers. It's like airline bulk booking you have. You take 100 slots, you take 50. He'll say, I'll take 90. Rate is fixed. So the NVOCC, he collects the cargo and gives the container to the feeder operator. And feeder operator carries the container to the destination. Let's make it simple, Bombay to Dubai. So X receives the container, loads it on board the vessel. So X issues a house bill of lading to the exporter. And he gives the container to the ship, the feeder operator, who gives a master bill of lading because it's his master who is on board and carrying the cargo. Container reaches the destination. So common sense, he will give it to the agent of X, who then hands over the goods to the ultimate, his consignee, that's the consignee or the receiver under the house bill of lading. So that's how the business works. So the person holding the house bill of lading will surrender the house bill of lading to the agent of the person who issued the house bill of lading. And that person, having received the original house bill of lading, will endorse a delivery order to the port on the copy of the master bill of lading that he has received. Armed with that, the clearing agent will go and clear the goods. But again, here in the containerization, you have less than container load LCL cargo and full container load FCL cargo. So when it is an FCL container, the ship owner has a disclaimer on the bill of lading, STC, set to contain. So he says, I have received a sealed box said to contain 900 bags of potatoes. But that's a disclaimer, said to contain. I don't know because I have received a sealed box. And he goes and delivers his responsibilities only to ensure the seal is intact on arrival. If the seal is intact, he is not liable. He is absolutely no liability. He gets out. That is where the customs issue starts now coming in. Because one of the most popular case was the old Shriram case in 1986, July, Justice Pence's judgment. My senior's chamber, I became a lawyer on 3rd July, and this was on 15th or 16th of July. And the work which I did in that matter initially was just carry the bundles, because I was also totally lost what was happening there. So it's a very interesting matter. So now going to the Customs Act, Section 30 of the Customs Act says the person in charge of the conveyance is the master of the vessel. I may be a little inaccurate in the numbers. Section 42 talks about no vessel shall sail out unless the goods landed have been satisfactorily accounted for. And who accounts? The person in charge of the conveyance. But if the master has to sit till all goods are cleared and sit with the customs clerk with a tally sheet and then keeps ticking, the ship will be stuck there forever. So under 148 or 146, or 142, 146 I think, or 148, he appoints an agent who, while filing the Import General Manifest, and he also gives a bond to the President of India that I shall satisfactorily account for the goods landed, you issue a port clearance for the ship to sail. So that is where the agent's role, the chauvelist matter, came into play. The customs were relying on the tally sheet issued by the port, because again, now coming to the Major Port Trust Act, under Section 42, the port takes charge of the cargo. Under the Customs Act, you can discharge the cargo only in a customs nominated area. You cannot just unload it anywhere. Port is a customs nominated area. So when port receives the goods from the carrier and gives delivery to the customs house agent who holds the delivery order from the carrier's agent. But if there is a shortage in what was discharged and what was delivered, who becomes liable? Bailment comes in, port becomes liable. So the tally sheets are never accurate, were never accurate. So the customs proceeded on the basis that the tally did say less was delivered. 100 bags have been discharged. What is delivered is only 80. You have not accounted for 20, twice the customs duty payable under Section 116 of the Customs Act, you have to pay. But the shipping line said, hey, I have discharged 100. My Import General Manifest that my agent filed said 100 bags are coming. See the vessel tally, which is prepared by my master and the stevedore and the port, that 100 bags have been discharged from the ship. Beyond that, I have no responsibility. If it is stolen after landing, what do I do? Or it has gone missing, what do I do? Customs were not accepting it. And in the chauvelist judgment is where all these things were discussed. What happens for FCL container, LCL container, liquid cargo, etc., etc. So the customs, this was the problem which was being phased with the customs authorities. So long as the container arrives with the seal intact, the owner has no problem. But if the seal is not intact, certainly the person will have to satisfactorily account for the cargo. Again, there are two kinds of seal intact. Now, those are the new problems which are being faced. We mentioned a short while ago about house bill of lading and master bill of lading. So who has to account? Because the house bill of lading person need not have received a full container. He would have taken an empty box. He has collected few bags from various exporters, consolidated the whole thing into one container, sealed. So the carrier received sealed container. But that is the person who issued the master bill of lading. I'm just saying, see the complications and the issues which you need to look into. Whereas the person who issued the house bill of lading has received less than container load cargo, not FCL container. So now who becomes liable to satisfactorily account? The customs authorities have two bills of lading. Again, now the issue will be, the carrier will say, the house bill of lading person will say, I did not file the import general manifest. It is the carrier who filed the import general manifest. Who has to account to you? Only he has to account to you. I don't have to account to you. And he will say, I have received a sealed container, I have delivered a sealed container. But even if the problem arises, because when the IGM is filed by the carrier, he relies on the manifest which is given to him by the person who issued the house bill of lading. So how do we correlate the whole thing? That is one of the major issues that you would find. In the other problem that we find nowadays is customs investigate. So they say, I'm going to seal, put a hold, I want to investigate. And then end of the day they issue a container detention certificate. And when they issue the container detention certificate, they tell the shipping line, you shall not charge any container detention charges. But the thing is, but the man has entered into a contract with the container owner that I shall pay you $48, I don't know the rates now. Then it used to be $48 for a 20-footer and $96 for a 40-footer per day. Though the container actual rental in reality, if you go into business, should be $1.50 a day or $3 a day. Because otherwise, the importer will use these containers as free storage. So these are all deterrents placed. So he agrees, if I don't give the container to you within 7 free days or 14 free days or 5 free days, I shall pay you this many dollars. How can the government of India come and tell, sorry, you can't do it? But contractually he has agreed to pay. So these are all various issues which will come up, which is really interesting to think about. So that takes care of the customs issue. Now going back to the port, we mentioned about 42 section under the Major Port Trust Act, they take charge of the container, of the goods. A consignee does not come forward to, before I go to the port, another issue which will come up, we were talking about cargo. Charter parties, we are clear, between two parties, A and B. In a contract of carriage which is governed by the bill of lading, we said bill of lading is a receipt, ownership document, and also a transferable document. So when A exports A and B, A is the seller, B is the buyer. A is based in Bombay, or let's say in Hong Kong, B is based in Bombay to sell, say, 100,000 tons of scrap. But these 100,000 tons of scrap is loaded in Shanghai by X. A is not the shipper. So the line will issue a bill of lading which will show X as the shipper. So with whom is the contract of carriage? In standard circumstances, X. Let's take it as a C&F or a CIF, cost insurance, where the risk passes on shipment. So contract of carriage is entered into with X in Shanghai. The seller is A, based in Hong Kong. The buyer is based in Bombay, B. But who takes delivery of the goods in Bombay is C. There is a high sea sale. So A is the seller, A and B is the contract. B and C have a separate contract, which is the high sea sale contract. A and X have a contract to ship 100,000 tons of scrap, but the contract of carriage is one per document, bill of lading. So the goods come, when they take delivery, or let's say midway, few containers have fallen into the sea, so instead of 100,000, you get delivery of only 90,000. Or let's say it's underloaded, incorrect document is mentioned. Something could have happened. But who is the ultimate sufferer in this? C. Because C has paid B, B has paid A has paid X. But the contract of carriage is between X and the carrier. So he goes to take delivery of the goods, and the carrier will say, "Who are you? My job is, I don't even know you, because you have taken delivery based on the endorsement made on the delivery order by by B, and you have taken delivery from the port. I'm not your carrier, my contract is with X, who shipped." So there could be various situations. It could be a named consignee. C could be a consignee if these sales have happened earlier. Or generally, where these are all international sales, you have a letter of credit open. The bank exercises lien, so the consignee will be shown only as to order. So X, having received payment from A, would have endorsed the bill of lading in favor of, say, Bank of China. A, having received payment from B, would have endorsed it in favor of Bank of Baroda. And Bank of Baroda having received B having received payment from C, would have endorsed it in favor of, let's say, HDFC Bank. And HDFC Bank, based on the credit facility that it has with C, or having received payment from C, would endorse in favor of C. C endorses in favor of his clearing agent, who goes to the port and clears. But how does C sue the carrier? Because the carriage is between X and the carrier. That is where Section 1 of the Bill of Lading Act comes. Where a consignee, which means a named consignee, suddenly I'm telling from memory, or where the property in the goods have passed upon or by reason of endorsement on the bill of lading. You see the words, property in the goods have passed upon or by reason of endorsement in the bill of lading. There are endorsements made in the name of Bank of China, Bank of Baroda, HDFC Bank. Can they sue? Because there will be an endorsement. Upon or by reason of property in the goods, because between the bank and the customer, the intention, because it's all intention contract, what the parties intended, there is no intention to transfer the property. So therefore, if, let us say you have taken delivery of the goods, bill of lading hasn't come, you give an indemnity to the carrier. I undertake to hold you indemnified, harmless, in case somebody comes with a bill of lading and you take delivery. You are still getting the bill of lading later, but no property has passed to you upon or by reason of endorsement in the bill of lading. These are the finer points in the industry that really works, you need to think about. So that's how the Bill of Lading Act would work. And similarly, you have one of the oldest cases was Aliakmon, 1985, House of Lords. Then comes I mentioned about the Ports Act, Major Port Trust Act. The port takes delivery of the goods, and the port has to give delivery of the goods to the person who holds the delivery order. Under section 61, 62 of the Major Port Trust Act, if after 30 days, within 30 days, the consignee does not come forward to take delivery, the port can sell the goods. Invariably, because there has to be a valuation to be done by the customs department, it doesn't happen because they have to work out what will be the loss of custom duty that will happen. Goods, I have had many cases were sold after 12 years and 15 years, the value just goes down. Sometimes it's a machinery will get sold for scrap for a small percentage of the actual value. Now, port storage charges have gone on for 10 years. So port says, you have used my place, you have to pay me ground rent. Now, who do they chase? The consignee has not turned up to take delivery. Who is the sitting duck there? The shipping line. But who is the shipping line? He is some foreign company. So his agent. Because he gave an undertaking to clear the goods. But the agent says, hey, you were to sell after 30 days, you did not sell. And under section 2O of the Major Port Trust Act, owner is defined of a ship including an agent. Fortunately, we succeeded. I'll tell you a very interesting matter. It was my baby. 4,350 rupees was the amount involved. First round in small causes court, the agent succeeded. Port's claim for deficit in sale proceeds. Because there was a deficit of 4,350 rupees, so the actual ground rent and what the sale proceeds was. He said, you agent, under 2O, you are the owner of the goods, so you have to pay. Small causes, intra-court appeal, agent lost. Civil revision application filed in the High Court, lost. Go to Supreme Court. I think it was Justice Kuldeep Singh's bench. Good man, we lost him recently. He said, my Sheikh Mohammed Rautar judgment, I have decided this, it has not been considered, send it back to Bombay. Came to Bombay. And that's the stage when the party approached me. And I was still in school probably when the whole history started. So, and Sheikh Mohammed Rautar, there were two. One is of a 5-judge bench of Justice Hidayatullah in 62 or 63, and then of Justice Kuldeep Singh, where Justice Kuldeep Singh said, that, there was an observation in the passing. In this case, even the bill of lading has been endorsed in favor of a consignee. So the port took a stand where it is not endorsed, you are liable, but that was not the interpretation the court we were giving. So the second round in Bombay, they lost, and that's the time they came. So I said, let's challenge. Huge stakes, though this one matter was only 4,350, some 25-30 crores were involved compared overall for that particular client. He said, sir, fees no problem, fight. We filed an SLP. That was one of those good, feel-good moments for a young lawyer. It came up before the bench, and the court told my senior, and the Attorney General was opposing. He said, this requires consideration. Bombay has said this, Calcutta has said something else. We need to look into it. And you should keep in mind, Mr. Shri, the art of advocacy sometimes comes in. I mean, you're all good lawyers. So I told my senior, sir, get it expedited. He said, all right. Lordship will at least stay the matter. What, 4,350 rupees? What stay? You pay. Then at least expedite the matter. And the court expedited, granted an early hearing. And then they remarked, well-drafted questions of law. And then my senior said, the credit goes to my junior. That matter we lost in the first round. By then, I then got called to the bench. Then it was carried, and another bench said these are repeated issues where we had succeeded in a similar issue from Kerala High Court. Kerala High Court, one of them was a judge now, had carried in SLP, and when that was being heard by the large bench of, three-judge bench of Justice Nariman, he finally held that an agent cannot be called an owner of the vessel for. That's when finally we succeeded. I mean, when I say we, means the shipping industry succeeded. So it was a major problem that the industry was facing. Somebody gives me a cargo to take it to Bombay. No line is expected to see whether there is a consignee available to take delivery. He brings in, unloads, the port takes charge, but port does not take action immediately to sell the cargo. And there is a deficit in sale proceeds. Now, if the line wants to mitigate its loss, let's assume the line was liable, how does it mitigate? By taking the cargo out. But under the Customs Act it cannot, because it is not the importer. And the customs authorities will say, you get an NOC from the person who imported, who is not even existing, who has vanished. So you're like tying my hands behind my back and asking me to fight. How do I do it? These were the practical problems. There was two huge shipping lines who got some 300 boxes from New York or somewhere in USA. It came, address was XYZ someplace, no such person ever existed. And what really happened was in US, they all dumped used tires. So somebody, I think from Pakistan or somewhere, I'm not sure, had hired a big yard where he would for $1 collect used tires, pile it up, and one fine day he hired these 300, told the shipping line salesman, hey, I'm going to give you 3 boxes for carriage to India, FCL containers. So this guy was looking for huge bonus in getting business for his company. He gave the boxes. The man stuffed containers with tires, used tires, sealed it, sent to India. And India, you cannot import used tires. So when the containers arrived, there was nobody to clear. Customs authorities opened the seal and found used tires You can't import, you can't re-export, what do? And then the ground rent starts mounting, payable to the port. Containers are not available to the shipping line for carrying on their trade. I'm only saying, I'm not what should be the law, but these are the issues which you will all come across when you are in the business. So those containers, in one case, it contained garbage, trash, including human waste. What do you do with those containers? You had to dig pits. In one case where I was involved, 24 40 feet containers containing seafood. And the exporter, because he did not fulfill his, it was an EOU, he did not, there was an investigation against him, he absconded, nobody came forward. After 9 months, 10 months, the containers started conking off. I mean, it started failing. Then you can imagine containing seafood, reefer containers failing. It would stink. So we had to file 2 writ petitions, one against the port and then against the customs, to have those containers devanned. Now how do you destroy the cargo? The client apparently arranged people who would work in mortuaries, who were drunk so that they wouldn't realize what's happening, dig deep pits, put it inside and close it. Because they also were suggesting, why don't you sell it as animal feed, this rotten fish. But then that was the time when the mad cow disease also had come out in England, so nobody wanted to take that risk. So these are the various problems that you will face vis-a-vis shipping industry, bill of lading, charter party, customs, and the port authorities. Of course, there is also the Indian Ports Act, where the relevant portion is section 11 or 14, where if a ship capsizes in the port, within the port limit, the owner has an obligation to remove it, and if not, the port can do it and charge 20% administrative costs. Then of course, marine insurance is another part which falls under the same bracket. I'm sure many would have been involved in insurance matters. Uberime fidei, utmost good faith, disclosure, non-disclosure, these are the primary issues that you will come across. There was a matter where I was involved, and thank you. She was a very large ore and oil carrier, VLOO, 215,000 tons, a kilometer long, on a funeral voyage. So the insurance was from the Alang shipyard, Alang anchorage to the shipbreaking yard. So that was called the funeral voyage because she was going to be beached to be broken. She was a twin screw, 2 engines of 20,000 bhp each. I mentioned about this in Pondicherry. From Singapore, where the client purchased, the insured purchased, she came with just 1 engine to Alang, and from Anchorage she proceeded on the funeral voyage. Close to because it was only just 9 kilometers, and the size of the ship, you cannot use a tug, because even if you use a tug, the length is not enough, because there the tugs operates like in childhood you would have thrown rockets like this, like a catapult. Oh, we did a lot of studies in that, sat with naval architects and all, how to, the squatting effect, the speed effect, engine speed effect, all that had to be worked into, sitting with surveyors and naval architects. She lost her rudder, drifted, sat 3,000 feet away from the designated yard. Alang, as all would know, is a tidal port. So every day there is high tide, then the water recedes, ebbs. So she sat. So when there was high tide, she would go up. When the water would recede, when there is an ebb, she will sit. 2 days later, she broke her back. Because she's such a huge vessel and sitting on rocks, you go up, go down, go up, go down, you break your back. So the assured gave a notice of abandonment, saying it's a constructive total loss because she has lost her species. She's no more a ship. I cannot move it as a ship because she has to be broken. Insurance company rejected the claim. See, the issues that will come across again is when does the limitation begin? Insurance companies many a times don't even reply. So you need to still calculate 3 years from the time the loss happened. If they have rejected, then maybe, well, you can say I'll get 3 more years. So she broke her back and we found a buyer who, the nearest yard, he bought the ship at, let's say, I'm just maybe at 60% of the insured value. So the balance is the loss we suffered and lodged a claim. Insurance company rejected, and one of the primary grounds on which they rejected was non-disclosure of material fact. And what was the material fact? One engine not working. You did not disclose that she was doing the final voyage only. She had only one functional engine. So we had to prove 2 things. A, we disclosed, and B, assuming we did not, it is not a material fact. We succeeded in showing that we did disclose, because the covering letter said enclosed. This one engine missing was only functional was in an addendum, not in the main contract. So the insurance company said we did not get the addendum. We got only the main contract and therefore you did not disclose. So the manager was cross-examined and the manager was asked, how do you, these are all, since there are lawyers here, I'm just telling this. How many policies do you cover, issue in a year? He said, about 300. What kind? Small claims, big claims, small, big, medium and large. So where would this come in? Large. How many did you issue? About 60, 70. Because that's where most of the ships go for breaking. Have you got all the files here? He said, no. All right. How do you keep the file? Do you open a separate file for each cover that you issue, or no, we put everything one over the other in box files. Once it is full, take another box file. Do you index them? No. Do you paginate? I said, no. So therefore, even if one piece of paper falls off the file, you wouldn't know. Yes, you are right. Next topic. So, so that's how I can't forget the fun we used to have during those sessions. That's one thing I miss, not able to cross-examine a witness. So the issue was, we also went to the extent of proving, with the help of witnesses, naval architects, master mariners, and other experts, to show, including this working of squatting effect, this 40,000 bhp engine is required for full throttle, fully loaded vessel, and therefore one engine missing for the funeral voyage was not a material fact. Because there can't be a straitjacket formula as to what is a material fact. You will have to link it to each case-to-case basis. So that's how so marine insurance is another subject where cargo covers are involved. That is, you have ICC A, B and C. So A is all cover, B less, C is further less. That's also a very, very interesting subject, marine insurance, which comes to it. Now we go back for a moment to the charter party. What is the law that you will apply? If it's an Indian owner, Indian charter is a regular contract act that you will apply. So just going back to where I started, there is no rocket science in any of these matters that you do. You need to just apply your mind. And the other provision of law which generally comes in is the Merchant Shipping Act, which governs the how. And one of the most relevant, even under the Carriage of Goods by Sea Act, is if there is a damage to cargo, you can restrict your liability based on the tonnage of the ship. And under the Carriage of Goods by Sea Act, they have the SDRs they apply, special drawing rights. Under the Merchant Shipping Act, you have for loss of life and for cargo or the ship, or collision damage happens. You restrict your liability, you create a limitation fund and deposit that money in the court. And all claimants, so you restrict your liability. This is very peculiar to the maritime industry. You restrict your liability to the fund that you have created. So so Merchant Shipping Act has a provision by which if there is a maritime casualty, marine casualty, that under 354 is limitation, 334, I think, or 3 is where a fact-finding inquiry happens, to be conducted by a person not below the rank of an additional chief metropolitan magistrate. So if there is a collision here, under the definition, if you fall within the marine casualty, is to find out a fact-finding. It's a commission which is appointed, and that its fact-finding inquiry is conducted, where they can also have the assistance of, like we have in commercial courts now, assessors to be appointed to assist the magistrate in ascertaining what really happened and in understanding. Because it's again a very peculiar term. When you say port side and starboard side, you still are confused. Oh, is it the left side or right side? So there was one matter where the magistrate would say, don't say port side or starboard side, he said left side or right side, you tell, because he would get confused. There are very interesting matters in the maritime industry, as much as you would find in the tax side, where it really makes you think. It's a very interesting subject. And it is not just one act that you have to look into. When you are a practitioner in the side of law, or that branch of law, you need to have a grip of all the provisions around. So I had a good time in that practice, and I have now, my memory doesn't help me to say anything more. I'm open to questions. 2 conditions: restrict to the topic. B, don't ask questions on matters which you are involved in or I might be involved in. Not 2, so 3 conditions. So, if there are matters pending in court, it would be a little awkward. And since everything is being recorded, I'll be a little... Yes. I took what, 40 minutes, 45 minutes?
Just have one question. For collisions that happen in the high seas, which vessel's jurisdiction will be applied or which law applies?
It depends, because if it has happened, you go against whom? The owner, the other vessel. So you can go to the country where the owner is based. The other way of looking at it, if A is at fault, or he feels that he might be at fault, there are jurisdictions where he can just go and set up a limitation fund, even though it is unconnected with both vessels or when she last sailed out where the cargo was loaded, etc. I had I think, Eleni is the name of the ship. Sorry, in Admiralty jurisdiction, we go by the name of the ship, not the parties. I had said in the passing that you cannot just walk into India and set up a limitation fund, which was disagreed with by a coordinate bench. And the law was amended to that extent. So you can't, if it's a Singapore, say a Japanese vessel, and another vessel is Panamanian, flying a flag of Honduras, an incident happened off Gulf of Mexico. You cannot take advantage of the inexperience here or the delay happening and come to set up a limitation fund.
Thank you, Chief.
What is the significance of sit to contain in a bill of lading?
It's a disclaimer. I do not know what is inside. What I'm getting is, I'm getting a box, a sealed box, container number so-and-so, with seal number so-and-so. The shipper says it contains 100 bags of potatoes. You can, to the extent of weight, you may say that there cannot be a disclaimer, because it's like Amazon. They receive a sealed packet, or a courier company, they receive a packet. You write in the booking note that I am sending books of particular author. So if they say, I have received books, because you can feel it, said to be of so-and-so, that is how, it's a disclaimer that I am not accepting what is inside the container.
But still, the liner can be, the person issuing the bill of lading can be sued, despite those...
So he will take the defense. He'll take the... See, nobody can stop anyone from suing. That's a defense he has. But going back to what question you mentioned, there was another interesting matter which I need to mention. Yes, thank you for... Thank you. You might have heard about... I mean, everybody would have heard about ship piracy. Yes, sir. One of the most... one of the places where it happens a lot is in the South China Sea. In 2000, there was a ship by the name Alondra Rainbow, which carried aluminum ingots, I think 7,000 tons of aluminum ingots. She loaded in Kuala Tanjung in Indonesia, was carrying it to Miike in Japan. And she was a Japanese-owned vessel flying the Panamanian flag, because all these Panama, Honduras, Liberia all issue these flags of convenience. She set sail, and the master was preparing notes to be sent to the owners and charterers, and there was a knock at the door. And he opened the door on the bridge, and there were people brandishing swords and pistols and guns. And the ship was hijacked. And they took everybody into the dining hall. Hands were tied behind their back, blindfolded, kept, except to use the washroom on gunpoint, and for them to eat one at a time. For eating, the hands were open. For washroom, hands and eyes were, or even eyes were not, they were taken. That's what the witnesses said. And after 2 days, there was a bump, and they were all, hands were one at a time. They were lowered from this vessel to another vessel, which in the shipping parlance is referred to as a rust bucket. It was a very old, poorly maintained vessel. And from this Alondra Rainbow, a life raft was lowered into that vessel, and all the crew were transferred, and the pirates took off with this ship. It's like a real movie you can make. 10 days. No, again after 2 days. No, this was overnight. The first 2 days later, which is at Pattaya, off Kuala Lumpur, the life raft was lowered. All of them were made to go into it, line cut, set adrift in the sea. 10 days they were floating. And our star witness was the master of the vessel, whom we had to give police protection because he was scared that pirates are dangerous. And he was saying how he had to control, they have rations on life rafts, that's basically sugar cubes. And they would catch fish, and I don't know how far, I'm a vegetarian, and he said if you squeeze sea fish, it would squeeze out fresh water. And that's how they were rationing water. And 10 days later, a fishing trawler off Pattaya, Phuket, rescued them after checking their ID, because they were also worried. One person had a photocopy of his passport hidden in his underwear. So he was asked to go up the ship to the fishing trawler, show his identity, and then they were all rescued. And then the Piracy Reporting Center, PRC in Kuala Lumpur, sent word world over about the missing vessel. Because the owners immediately, they lost contact with the vessel. And then they got message, a vessel which is matching the description, but of a different name, was seen off the coast of Kerala. Al Shuhada was a new name. This happened in 2000. And the PRC message, so Dornier aircraft from Goa Coast Guard, then the Navy vessels from Bombay and Kerala went on high sea hunt. 350 nautical miles off the Indian coast, that vessel was intercepted. They surrendered. And the ship was towed to Bombay. So 15 pirates, all Indonesians. And how do we identify this is the vessel? So the master was called from Japan. By then they approached my senior, the prosecution, because nobody knew how to handle. And my senior saw me sitting in the office. He said, "You come here, you work pro bono." I said, "Excellent," because I would never get a chance in my... So all once in a lifetime matters that you get to work on. Money doesn't matter then. So we the master first said, in my cabin, the wash basin had a crack. And I had put an M seal under the wash basin. So with punch witnesses, we went to identify, found the M seal. An aluminum piece was found somewhere in a corner, because by then they had already removed the cargo. Then when we use flames to remove, see, whenever a ship is built, the original name is always, it's not etched, embossed on the ship. So these people had painted over it. And we used flames to burn that paint off, the original name appeared. And that's how the ship was identified, because you need to first identify that this is the ship that was hijacked. But the biggest problem that was faced was jurisdiction. Japanese vessel, Panamanian flag, pirates were Indonesians, hijacked off in South China Sea, because the place of crime also is not here. And she was intercepted 350 nautical miles away. Our economic zone is 200, and the territorial is 12 nautical. So we got the ship inside, and then we did a lot of research. The old AIR manual of, I think, the third or fourth edition was found, which had an act called Admiralty Colonial Offences Act 1849, which had not been repealed. So that was still good law. And Section 1 provided that, in short I am saying, if a felon is found in the high seas and brought into the colony, the courts of the colony will exercise jurisdiction as if the offense was committed within the colony. And applying Safety of Life at Sea Convention, which India is a signatory and also had ratified, we said this court will have jurisdiction. And I was assisting pro bono. I was not appointed as a special prosecutor. So my name did not feature anywhere, though I spent about 600 hours on the matter. Because the judge said, the sessions judge, Judge Vacha, he said, "You're not appointed, so how can I give credit?" I said, I pleaded with him, at least give credit that there was some youngster who assisted the court. He did not relent, but anyway, but there are magazines which reported about my presence there. But this was a very interesting matter. And all the crew, all the pirates were given 7 years RI, because many of the charges could not be confirmed because of various reasons. And by the time the trial got over, they had spent 6.5 years in the jail. And when they went in appeal, High Court said, it's okay, now set them free. That's another very interesting matter. We have had situations where I've spent days on ships recording statements of the crew if there was an incident. Off Bombay some years ago, it was 2011, a vessel by the name MV Nordlake, a Norwegian vessel, I was representing the hull underwriters there, collided with a Navy vessel. The whole family, naval officers, had gone on a holiday. And there was a collision. So the naval vessel listed a bit. She was taken alongside and then she capsized. Again, yesterday in the court or somewhere they were saying there's a difference, I should tell you, sinking and capsizing. So in one of the marine inquiries, there was a major issue when the magistrate said the ship would sink. And the witness said, sorry, I said the ship would capsize. And he refused to sign. These are all finer points which we need to keep in mind. He said, I refuse to sign my witness statement because I lose my job if I sign the way it is recorded. So there are a lot of interesting work that you can do in that particular field. Thank you.
Yeah, my question is also going to be something like that. Your Lordship has mentioned that the Bombay, Madras and Calcutta High Courts exercise admiralty jurisdiction. And in Bombay, you could get an order against a ship that is sailing anywhere in the Indian territorial waters. What happens if there is a conflict of orders by different courts? Is there a possibility of a conflict, and if there is, how is it?
The possibility is remote or practically nil, I would say, because if Bombay arrests a ship, all claims against the ship would also come to Bombay. And if Bombay has arrested, there is no bar in Calcutta also arresting the ship. There is no bar. But the owner would say, it's already under arrest. If he wants the ship to be released, he'll put bail in Bombay as well as in Calcutta. If not, whichever court sells the ship first and the sale proceeds comes in, then all matters have to be against the sale proceeds. So Calcutta will then stop exercising jurisdiction, will say, now you have proved your claim here, but executing, you have to go against the sale proceeds in Bombay. But,
Thank you. Thank you.
There was one judgment, I forget the name of the ship. One of the recent judgments sitting in appeal must be in January to April 23. GeoWave Commander? There we have dealt with on similar situation. Yes, please.
I just want to know about the impact of Admiralty law on internal container departments, ICDs. What is the impact of Admiralty law on that?
No, it depends on whether the claim is against the ship or it is against an NVOCC. If the inland container depot is only an extension of the port. It's an extended customs bonded area. So when the industry kept growing, so they created an ICD. There won't be any impact on that. But since you mentioned it, I had made a note in my old note, I forgot. Thank you. Income tax matter. It was an appeal which a shipping line filed against the order of the Income Tax Appellate Tribunal, which did not extend the definition of shipping under the India-Norwegian DTA. Because, see, what happens is as business grows, as competitions grow, people come up with very innovative ideas. A standard is port-to-port shipment. The extended standard is from ICD. You receive cargo, say in Ludhiana. You have an ICD, you get cargo from all that area, consolidate it, move it to Kandla, which is the nearest exit port, and load it on board a ship. Many lines came with an innovative idea of giving a value addition to this because of the competition. And the value addition is, he will tell, let's say, Hero Cycles, I'll come to your factory with empty containers, I'll consolidate, I'll stack it, I'll pack it, I'll move it from your factory to the ICD, where the customs examination happens, and then export it. So the issue was whether this segment from the factory to the ICD would fall under the definition of shipping for double taxation avoidance agreement. So the council said that it is covered matter. I disagreed and we had to spend 15 minutes to understand how the industry would work. And then I framed substantial question of law as to whether this segment, I don't know what has happened after that, whether it was decided, may not have been yet, whether that would fall under the definition of shipping for double taxation avoidance agreement purpose. These are all so many new things which are coming up. So it's not just one straight port-to-port shipment, cargo damage, etc. that arises. The issue is, what happens if there is a damage to the container, cargo, when being moved from the factory to the port, ICD, or from ICD, because from ICD to port also it is moved by one of those canalizing agents like Container Corporation and all, because you're moving it from one customs area to another customs area. So who moves? Who is responsible? Oh, interesting matters would come up in that segment of business.
Thank you very much.
Speaking as a judge, do you find it easier to decide issues arising from less regulated fields where there's more common law versus more regulated fields like income tax or customs where there's a lot of statute and regulation?
Difficult to answer. It all depends. Frankly, I have enjoyed my last 12 years plus journey as a judge. If one is we apply our own mind experience, two, if the lawyer is good, willing to explain. None of that, I have not found difficulty in any field, whether it is regulated or not so regulated field. So it's very difficult for me to answer, but it's fun. I should be candid. I said the other day that in Bombay we used to work on first and third Saturdays. I said that in the Bombay bar. Courts don't function. Of course, the office would function. And I'll be in the chamber from 10 to 5:30, like any other working day. And on second and fourth Saturdays, I'm a teetotaler, but by Sunday, 3 o'clock, I'll start getting withdrawal symptoms. And I need to go back to work onto the desk. So there is no field is difficult. It's your mindset, how you enjoy. If you enjoy your work, nothing is difficult.
Thank you, sir, for that extremely enlightening session on and what really struck me was the interplay between customs law, admiralty law, IBC and the Companies Act and even insurance law. Now,
Friends, I think we should give a standing ovation to our chief who spoke for more than 1.5 hours uninterruptedly with all standing. Thank you. Before that, in fact, I happened to meet Chief for the first time at Coimbatore, and I introduced myself to him saying that I am Madras Tax Bar President. He said, "Oh, which field you are?" I said, "Both direct and indirect tax." In the income tax, what is there? We have left everything. Everything is over. Every section was there. You have a judgment on that. In fact, yesterday when we were before the chief, in span of 21 months, when he headed the tax bench in Bombay High Court, it is surprised to note that he has disposed of more than 12,000 tax cases related to income tax. That's Thank you.
I now request the members of the dais, the Honorable Chief Justice and the Secretary and the President to take the seats below so that, because now the PowerPoint is finally working, so we can proceed with that.
I request Natarajan sir to kindly.
See, this MTB, it had its origin during the corona pandemic. Today we have seen a lot of disruptions in the video, Lordship missing his notes, and again the video fluttering. But it is the feature of MTB because
What I want to remember, it's indeed my pleasure and privilege to present this brief recap, the wonderful trip down the memory lane. MTB webinar series. The central nervous system of the Madras tax bar, which connected all MTBians intellectually and stitched an eternal bond of camaraderie between us. When the whole world was waking up to the doomsday, we at MTB were having an intellectual merry-go-round.
it was actually Mr. Satish Sundar who mooted the idea and started it as a WhatsApp group. And then during the COVID pandemic, we went on to conduct webinar after webinar. And we had, and most of these webinars, almost everything was pioneered and anchored by our youngster, Mr. Prithvi Chopra. And many people were behind the success of all these webinars, like our AP Srinivas, Satish Sundar, and Raghavan Ramabhatran. Next. And we had around 10 honorable sitting judges and 5 retired judges, 2 tribunal members, and 2 top bureaucrats, and 14 senior advocates, and 72 advocates among ourselves addressing all these webinars over a period of nearly 2 years. Next. Now, as honorable judges, we had Justice Rajiv Shakhtar, who was working as a judge in Chennai and later transferred to Delhi. We had Justice S. Vaidyanathan, who recently retired as the Chief Justice of Meghalaya High Court. Justice R. Mahadevan, who is now sitting in Honorable Supreme Court. Justice A.K. Jayashankaran Nambiyar from Kerala High Court. Our own Justice M. Sundarji. Dr. Anita Sumant. Honorable Justice C.V. Karthikeyan. Honorable Justice Mr. G.R. Swaminathan. Honorable Justice Mrs. P.T. Asha. And Honorable Justice Mr. N. Anand Venkatesh are some of the judges who have addressed our webinars over a period. Then, from the retired judges side, we had Justice Kannan, and Justice Vinit Kothari, and Justice R.V. Ishwar, and Justice Pushpa Satyaranayana, who addressed our webinars, and Justice Vinod Kumar Sharma also addressed many of our webinars then. And it is very happy to note that our bar itself is blessed with so many seniors and juniors who are very good. And we had none other than the chairman of the Central Board of Excise and Customs at that time, Mr. M. Ajit Kumar, who is currently the member of the SISTAT, and Mr. Vasa Seshagiri Rao, who is also the member of the SISTAT, and T.R. Senthil Kumar, who is currently the judicial member in IT80, and Mr. P.G. Chacko, one of the illustrious member retired from the SISTAT. All of them have addressed our webinars. And senior advocates, we have many, and we are all happy to note that this Madras tax bar has contributed a lot in the development of tax jurisprudence. We had the all-powerful, the entire country knows Mr. Aravind Dattar, and we are happy to say that he is from our own Madras bar. And we had Mr. V. Sridharan addressing us, we had Mr. Lakshmi Kumaran addressing us, and our own senior advocates like Mr. A. Tyagarajan, and from Delhi, at the then ASG Vikramjit Banerjee, Mr. Om Prakash, Mr. R. Kumar, and these are some senior advocates who addressed us. And we also had our own in-house speakers like Mr. Lakshmi Kumaran, Aparna Nandakumar, and Mr. Vaidishwaran, who are all, Mr. Jay Kumar, who are all known in the tax circle as great speakers. And we had our own Raghavan Ramabhatran, Mr. M. Swaminathan, who was an expert in indirect tax law and who has now become a member of the Central Administrative Tribunal, and who is also gracing this occasion today, was also one of the speakers. And we had so many speakers from our side, Mr. T. Ramesh, Hemalata, Joseph Prabhakar, Muthu Venkatraman, and whatnot. So we are very happy to say that our bar is enriched with so much of talent, and we are also known for sharing the talent through this webinar series. Maybe of late in the last 1 year, there has been a dip in the number, which we will try to catch up with the momentum which is given today by our Honorable Chief Justice. We certainly hope the momentum will pick up. Yes, next. These are all some of the speakers. And the list is endless. And it will also, these are all our youngsters from our bar who have addressed various sessions on various topics of taxation. Yes. Next. The number speaks for itself. And we also had very unique presentations, like we also honored various legends of the Madras tax bar, starting from C. Natarajan and even before him. And we are very happy to say Mr. Chopra, our current president, who is also the, I think, 4th generation lawyer. And we are very happy to have him as our president now. Next, go. We had our 100th webinar addressed by Dr. Vinit Kothari, Justice. And we also had some unique webinars, like in the format of dramas, in the format of songs, talks, and we also had other general topics like health, yoga, those type of seminars also we had. So that is our tradition. This tradition we would like to continue in the ensuing years by organizing more and more physical meetings as well as webinars on various topics of importance, so that we will have our professional development. And these type of meetings also ensure a good bench bar relationship develops. So thank you, Your Lordship, for the time spent here, and nearly for 1.5 hours standing and speaking, we are all overwhelmed. That shows your love for the subject. Thank you. And a small video. There is a small video which will say about the doyens of our Madras tax bar.
Thank you very much. May I request the dignitaries to. Thank you for the audio visual, and thank you Natarajan sir for giving a voiceover to the presentation. Now I request our secretary, Ms. L. Maithili madam, to come and deliver the vote of thanks.
Honorable Chief Justice of the Honorable Madras High Court, Justice Mr. K.R. Shriram, senior counsels, several dignitaries, members of our own bar of the MTB who have now become members of CAT, Mr. Swaminathan, Mr. Soundarajan, member right EAT, and dear friends, a very good afternoon to all of you. It has been to talk about how the morning began and continued. The first thing that comes to my mind, for all the forgetfulness we started with, it was the most unforgettable morning with the expanse of laws, of various aspects of shipping laws that were touched upon. His Lordship took us out of our own comfort zone into the choppy waters of shipping laws, getting us all ready to enter the choppy waters, really more like a Poseidon adventure into so many aspects, starting it was talking about the ghost that indirect taxes is for taxation laws are for a lot of people, and which we have come to believe is Casper the Friendly Ghost. But now shipping laws too really has been made to feel so much, enticing us into plumb the depths of the shipping laws and examine its various aspects. It's fascinating, to say the least. And as for the Honorable Chief Justice telling us about being judged by lawyers, I don't have even an iota of doubt that every single person sitting here is unanimous, and the entire audience here is unanimous that they had a stupendous time. It was a beautiful learning experience, having us all wanting more. We want to learn more and more of all that he touched upon. And the nuances of the law really are something that has caught all our imagination. It's just demystified shipping laws for us so wonderfully. And I'm sure all of you are going to rush back and look at the various judgments he's referred to and see what more they can get out of it. And also in his beautiful, the humility of presentation, in the manner in which, as a young junior, how he worked with such dedication and pro bono work, and the love for the subject which is a lot more than what money can give you, the satisfaction of working on matters, and the credit that was not given to him for those hours of work. I noticed that this has left an indelible impression in his mind, because in his judgments, by contrast, there's no one whose contributor in any manner is not referred to and say their distinguished contribution is referred to in his judgments. I mean, that is something we all must remember, give credit where it's due, which he has always made it a point to do plenty. And also the ebb and flow. We went into insurance laws, into jurisdictional aspects. It is definitely, he made us understand, his Lordship made us understand, it is no rocket science, but it is probably as interesting as reaching the moon on a rocket. So with all the knowledge that we had, we still have to gain on the subject. And what is fascinating is how seamlessly he put together such diverse aspects of shipping laws, which, it is really, I think, left us waiting to examine more of the shipping laws and other aspects of it, if if at all. 1 hour went by, more than an hour and a half. It didn't feel like it at all. It was such a wonderful session. And I know as any of this vote of thanks that comes in, particularly the 80s comes just before lunch, so I cannot go on forever on this. But MTB has now been adorned and has with this lecture, and we are all set to sail into new waters. Thank you very much, Chief. It has been really amazing. Thank you very much. My special thanks to the hotel and to Mr. Jaishankar, the PS to the Chief, who we have traveled so much from extending the invitation, going and meeting him, getting appointments. And it has been an all-round such a pleasant experience. And Natarajan, of course, took us through the journey of MTB. I'm glad with the voiceover, with those little technical glitches, the audience has been very patient. Thank you very much for being here with us and making it such a wonderful, the question and answer, not to miss out. Very interesting questions, which got us thinking more and which the Chief took on with such ease, which he was ready with the right, however, it would set him into that field into greater depth. Each question, we could have had another session on that with the kind of knowledge, the wealth of knowledge that he has. Thank you very much. Please enjoy your lunch. Thank you. Very, very grateful indeed for this opportunity. Thank you.
We now have to stand for the national anthem. Jayalakshmi can lead the...
Yeah, come.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाता जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you. I invite everybody now to proceed for lunch.